Imagine this. Two people are in a dispute over land. In one place, the case is not decided by any written statutes or formal codes. Instead, elders gathered and the decision is based on what has always been done in the community. In another place, for the same case, the judge opens a thick legal code, reads a specific article, and delivers a ruling based strictly on the written law. One same problem, but completely different idea of what law actually is. And this leads to a deeper question. How can law exist in such fundamentally different forms in modern societies? Because here is something even more surprising. In some systems, law is written in books, codes, and statutes. But in other systems, law is not written anywhere at all, yet everyone still follows it. So which one is the real law? The answer is both. But they come from completely different foundations. One comes from tradition, the other comes from the state. To understand this divide, we need to explore two core legal concepts, customary law and codified law. Let's begin with the older system, customary law. Customary law is a system of rules that does not originate from legislation or written codes. Instead, it develops gradually from long-standing traditions, repeated social practices, and community acceptance over time. In legal theory, scholars describe it as norms that become binding because society treats them as obligatory. So in simple terms, customary law is what people follow because this is how things are done. It is not written in a statute book, it is written in social memory. So how customary law works? Let's return to the earlier example. If a village has always resolved land inheritance by giving property to the youngest child and everyone accepts it, then that practice becomes law. No parliament enacted it, no judge drafted it, but it still governs behavior because its authority comes from social acceptance, not the state. Key features of customary law. So, mostly customary law are unwritten and transmitted through tradition, enforced by community pressure, flexible and adaptable over time, and varies between regions and cultures. So why does it matter? Customary law plays a crucial role in many societies because it resolves disputes quickly, reflects local identity and culture, and operates where formal courts may be distant or limited. International legal studies, including UNDP and World Bank research, often show that customary systems remain important in rural justice delivery, especially in developing legal systems. However, customary law also has challenges and limitations. The first one is it may differ from one community to another. Second, it is not always written or verifiable. Third, it may conflict with modern human rights standards. And last but not least, it can lack legal certainty. So, while it is culturally powerful, customary law is not always legally uniform. But as societies grow, as trade expands, cities develop, and governments become more centralized, something changes. People begin to ask, what if law was written down clearly so everyone follows the same rules? This question leads to the development of codified law. Now, we move to the modern legal structure, codified law. What is codified law? Codified law is a system where laws are written down and systematically organized and formally enacted by the state. Instead of being passed through tradition, Codified law is created through legislative authority, such as Parliament. So unlike customary law, which live in practice, codified law lives in documents. What does codified law look like? It is usually organized into legal codes, such as civil code, criminal code, commercial or business laws, administrative regulations. Each code contains written rules that define rights, obligations, and legal consequences. What is the historical origin of codification? Codification became especially important in modern legal systems after major reforms in Europe. One of the most influential examples is the Napoleonic Code of 1804 in France, which aimed to unify fragmented legal traditions and ensure equality before the law, and to make law accessible in written form. So this model influenced many civil law countries around the world, including Cambodia. What are the key features of codified law? Some key features of codified law are, first of all, written and publicly accessible. Second, created by legislative bodies. Third, apply uniformly across the country. Fourth, enforced by courts and legal institutions. And last but not least, codified law is designed for legal certainty and predictability. Why does it matter? Codified law is important because it ensures consistency in legal decisions. It allows citizens to understand their rights in advance. It supports governance in complex modern societies, and it strengthens the rule of law. In short, codified law transforms law from tradition into a structured national system. Now that we understand both systems, let's bring them side by side. Because the real insight is not just what each system is, but how fundamentally different their logic is. Customary law is built on tradition. It is not written in books, but in social practice, in the way communities have always done things. Its authority comes from acceptance, not legislation. People follow it because it feels natural, familiar, and socially binding. And because it grows from lived experience, it is flexible. It can change gradually as society changes. But that flexibility also means something important. It is not always uniform. One community may follow one version of a rule, while another community follows something slightly different. Now, compare that with codified law. Codified law is the opposite in structure. It is written, formal, and deliberately organized by the state. Its authority does not come from tradition, but from legal enactment, meaning it is passed by a legislative body and recognized by the legal system. This makes it highly structured and predictable. The same rule applies across the entire country, regardless of region or custom. And instead of being enforced socially, it is enforced through courts, judges, and legal institutions. So if we simplify it, customary law is living and social, codified law is written and institutional. One evolves through practice, the other is designed through formal authority. And this difference is not just technical. It reflects two very different ways a society understands what law actually is. Now, here is something important. In reality, most countries do not rely only on one system. Instead, they operate under legal pluralism, meaning multiple legal systems exist at the same time. For example, customary law may still influence family dispute or rural land matters, while codified law governs courts, commerce, and criminal justice. So even in modern legal systems, tradition has not disappeared. It continues to operate alongside formal law. So, when we study law, we are not just studying rules written in books. We are studying the evolution of society itself, from community traditions passed through generations to written legal system enforced by the state. And modern legal systems are not replacement of one by the other, but a continuous interaction between both. So, final line. Law is not only what is written, and it is not only what is traditional. It is the balance and sometimes the tension can happen between both.